All right, Mr. Bollinger, you are the appellant, so you go first.
Good morning, may it please the court. My name is Aldo Boliger. I represent myself and my law firm, which are the appellants. I'd like to reserve 3 minutes for rebuttal.
You got it.
Thank you. In this case, I think the facts are important because the case law is actually fairly straightforward. There's not a whole lot of cases on point and not a whole lot of gray area. So I would like to point out some of the facts. I'm going to try to get through them pretty quickly.
Well, let me ask you one question because we have read the briefs. I know the facts are important in your case, but when you sign the LOP, the letter of protection, you claim you did not sign it individually. Where is that argument preserved, and how do we agree with that?
The arguments were that argument was preserved in an affirmative defense, and it was also preserved in response to.
Well, I looked at the LOP. Where did you qualify your signature, saying on behalf of the firm?
I see. I misunderstood you, Your Honor. There was no signatory line for a corporation. The LOP is made out to my firm. It's got my firm at the top. It says Boliger Law Group represents Ms. Frenzy, and an employee at my firm signed it with a signature stamp. The employee only has authority to use a signature stamp for corporate business, but of course, employees don't always understand. You're supposed to have a corporate signature line. So at best, the LOP is ambiguous. And it says when somebody challenges the capacity of a signatory, then the court has to look at parole evidence to resolve that issue. Now, I filed a motion for summary judgment. I attached all the parole evidence. I attached a copy of my signature stamp and stampings, so you can see it's not a signature that was put down by me. And I made all these points that there's no signature line in the LOP. There was no response. Now, Rule 1.510 requires a response to a motion for summary judgment. There was no response. There was no contradictory evidence, and the argument that the LOP was clear on this issue, or clear and convincing, or unequivocal, was never even made at the hearing. Instead, there was a 7-page single-space order entered by the court that the appellee drafted, and so that's completely unfair. And not only that, but Rule 1.510, the new rule, requires the court to make findings and rulings on the record. So when I mentioned this repeatedly at motions, I was told I should take it up and that the court's not going to make rulings on the record. So that's that argument in a nutshell, Your Honor.
Okay, I mean, there's a lot to unpack in there, but it sounds like you're arguing it's not a matter of interpretation, it's a matter of law, that LOP was not signed by you individually for various reasons, and the court couldn't weigh one way or the other. They had to accept your version of the facts. Is that true or false?
It's mostly true. At the very least, the court was required to look at parole evidence. That's what the case states that I quoted, because when you call the capacity of the signatory into question, the court has to look at it unless the court says it's clear and unequivocal.
Did you offer parole evidence? Did you offer?
Yes. Yes, I offered all the parole evidence was attached to my motion for summary judgment on this point. And there was no response in opposition, which is required under 1.510, and no evidence in opposition to it. So the court had only my evidence to look at, my evidence, and still and did not make any ruling on that evidence, then did not state anything at the hearing.
I got you.
Finding.
Thank you.
Okay. So this case basically starts from 2016, when my firm represented Ms. Kimberly Frenzy in a personal injury action when she was involved in 2 accidents. In 2018, the case was settled at mediation because it was deemed too risky to continue, because Ms. Frenzy's testimony damaged the case and because of some liability issues. Now, the total settlement was for $235,000, which is less than the medical bills confirmed just prior to mediation.
What was the difference between what the settlement was and what the total medical bills were?
They were
short.
Okay, I think they were about $300 and some odd $1,000. But then immediately after the 2018 mediation, when I sent out faxes to confirm and reduce the balances, 2 of the entities that stated they use the same billing company said that there was a mistake made, that their billing company forgot to include $172,000 in charges. So at that point, I continued to try to reduce, and with 13 different entities, there was no. Sometimes people didn't get back to me. People
No, I
were
understand. So everybody had a letter of protection, including the person that ultimately got judgment against you?
not everyone, but I'd say 70 to 80% of them had letters of protection. But the Florida bar requires me to notify everyone and include everyone in the lawsuit. So I included everyone that had a balance.
What was the money interplayed? Is that what happened?
Yeah, so I took out my firm's fees and I interplayed the remainder of the money, which there's nothing wrong with that. There's nothing wrong with that because so long that the client allows it and doesn't challenge the fee, you can do that. The
Client get
Florida,
anything out of this case?
pardon me?
Did the client get any money out of this case?
Yes, the client got money out of this case, and how the client got money is because both the interpleader case and the equitable distribution claim both said that the funds are not just earmarked for medical bills, but they're also to make the client whole. So when all the people that appeared and weren't defaulted saw that I'd made previous attempts to do a pro rata payout, I was pleaded with not to go into interpleader, not to walk away because they had 6 or 7 attorneys and that they would all have to charge their clients and it would further deplete the source. And they said, okay, we will split whatever it is between the medical bills and your injured client. So that's how my client received funds.
So the providers agreed to reduce their fees before you settled with the tortfeasor.
No, I'm
Other way
talking.
around.
I'm talking about after the interpleader and equitable distribution of 2019 action was filed. I received contact from the various providers, and they all put themselves on an email, and they said, "Look, we don't want you to walk away. It's going to cost our clients a lot of money. We have 6 or 7 attorneys having to argue over these funds that are now going to be interpled. Please don't walk away. We can come to an agreement.
Is that the normal sequence of events that if you don't get enough money to pay all the providers that you normally just settle a case and then worry about reducing the provider's fees, or would you do that first and then settle?
No, that's the normal way. That what you do is you confirm all the fees before mediation, so you know what's outstanding. You make sure you have recent figures, which was done. But then 2 weeks after the mediation, we found out, like I stated, that 2 of the providers used a billing entity that claimed there's another $172,000 outstanding. But the bigger concern was really the insurance companies weren't going to pay the funds in the first place the full amount because the medical bills under LOP are sometimes they're accrued on a cash basis, and these are 4 or 5 times what the local billing rate was. So there was never going to be a $400,000 recovery, nor if this case would have been tried, would these medical providers been able to recover those type of charges because they're just unreasonable. You know, when you have insurance or
Well,
Medicare.
that's just kind of a separate issue, though, right?
Well,
That goes into why they settled for less than 100%.
yeah, it's one of the reasons why they were settled for less than 100%. But it is a big issue in this case because the trial court here has said these are liquidated damages. I'm responsible for all of them, even though they're charged at 4 or 5%, 4 or 5 times the going rate. So I have no way to even challenge the medical bills. And the case that was cited by appellee is not even on point. It's a case where an attorney's fee claim was deemed to be recoverable without a trial on damages because the agreement stated what the attorney would charge as an hourly rate. The LOP obviously doesn't have any type of rate for the services charged. So I have no way to even challenge it. And I'm now responsible for $60,000 in an appellee's inflated medical charges in this in the judgment.
Mr. Bollinger, I have a very simple question.
Yes.
The interpleader named your client, and your prayer for relief was that the plaintiff be dismissed and all the defendants remain, and the court decides and equitably distributes what they're entitled to, correct?
Correct.
Okay, you did not file the remaining funds in the court registry, did you?
I held them in trust.
Yes or no? Yes or no? I'll take that as a no.
It's a no.
You would agree with me that if you had done that, that it would have been to the court with its authority, jurisdiction, and power to tell each and every provider what they're equitably entitled to, correct?
Well, I don't agree.
Yes or no?
No.
But you obviously don't understand interpleader then.
No, I do understand interpleader. Just the court is not going to dole out funds to parties that were defaulted, because when you default, you waive your
The
balance.
court deals with default parties the way the court deals with them. You decided to settle this case, and you testified that you were not going to communicate with defaulted parties, correct?
No, I never said that. Defaulted, whoever would call me, I would return their.
Testified, why would I call them? They're defaulted.
Right.
I'm just trying to get to this simple issue, because the issue is you settled this case, but you didn't settle with all the providers, correct?
I settled with all the providers that appeared, yes.
Correct. But
Yes.
there were some left who got defaulted, correct?
Correct.
Okay, but when you filed this action, your pleadings pled that there are letters of protection with these particular providers. And you would agree with me that if a provider didn't answer, that those pleadings that you made are well and true, correct? They're deemed
Correct.
well and true,
Correct.
which would mean that Dr. Tolley agrees that your pleading is true, that there are valid letters of protection. He had one, he's failed to answer, correct?
Correct.
Okay. So, but, sir, if you had done that and given the money to the court and let the court take it over for, according to the relief that you pled, it would have been up to the court, not you, to decide what they're entitled to and deal with the defaulted parties. But you decided to do something differently, correct?
I did. I was taught, in hindsight, I should have done that. I should have walked away, but I felt bad for these parties saying they don't want to litigate the remainder of the interpleader. So I did what they asked me to. And there were two counts. There was not just an interpleader count. There was a count for equitable distribution and one count for interpleader. So both of them asked that the funds be paid out on a pro rata share. And so and I have the exact same case that actually deals with this type of an issue. It's find it here. It's the Balfour Beatty Construction LLC versus New Era Lender case. While it's a middle district case from 2017, I'd like to point out that both the federal and state interpleader rules contain the identical language. It's just organized a little bit differently. But in Balfour, exactly like in this case, a party was defaulted via clerk's default for failing to respond to a complaint. Balfour stated that the act of failing to respond to suit and entry of a clerk's default triggers the forfeiture of the party's claim. Also, like appellee, the defaulted party Balfour failed to move to vacate the default. Balfour then points out that without the ability to default and move forward, that the trial court would not be able to resolve the interpleader action. Last, the non-defaulted parties in Balfour, like here, also stipulated to a distribution of the res. There was no requirement that the parties continue to litigate and expend resources litigating stage 2 of interpleader and exhaust the res on that. So this case is exactly on point. And you have appellee's case, which he relies on, is the Raphael Industry case versus Go, and that's the 4th DCA 1990 case. And in that case, it's completely different, because that case there was a clerk's default entered, and then the party appeared, filed a motion to vacate the default, and the trial court refused to hear the motion to vacate.
You don't have a default judgment being entered by the court here, correct?
No.
You never moved to convert that default into a default judgment by the judge.
No.
So there's no reason to vacate anything, correct?
Well, a default has to be vacated before somebody can appear and argue.
But that didn't happen. That's what I'm saying is you don't need to do that unless something else happens that didn't happen in your case.
Right. It didn't happen in my case, but I'm pointing out in their case that it's completely different, because in their Raphael case, the party appeared, moved to vacate a default, and then the trial court refused to hear the motion to vacate. an appeal was taken, and then the trial court said under those circumstances, the trial court should have heard the motion to vacate and then continue with the case. It wasn't just entitled to pay out and deem the party to have defaulted and waived their balance. So that's
I want to give you a heads up real fast. You wanted 3 minutes for rebuttal. You're at your 5-minute mark. Okay.
okay.
Keep going if you want to.
Okay, so I'm not going to get into the facts because it appears the court's pretty aware of the facts, but I'd like to point out that the big issue here is that the plaintiff lacks standing at the initiation of this case, because if you look what the first two complaints say, they state plaintiff Thomas Tolley, MD, an individual, resides and practices in Pinellas County. Now, Dr. Tolley admitted at deposition he has no personal interest in the LOP at all, and that it is held by his corporation. Moreover, the 2019 action was brought against the corporation. So I believe that plaintiff here purposely, appellee here purposely pled Dr. Tolley so they could get around the default that happened in this case. So there's longstanding cases from this court in People's Trust, that's a 21 case, and also Judge Sleet in May versus PH Mortgage Corporation. They both say the same thing. A party must have standing to file suit at its inception and may not remedy this defect by subsequently obtaining standing. So,
is there a motion to dismiss on that basis filed below that was denied?
Yes, I filed a motion for summary judgment on this ground, and it was denied. And less than 3 weeks after the motion was filed, counsel for appellee ran off and filed an exact same action so it could hedge its bets. So that action is now stayed in the circuit court because appellee knows that this case is subject to dismissal and wanted to make sure that the statute of limitations wasn't going to be blown. So that's why that case is sitting there. They know that this is supposed to be dismissed, and that you can't substitute, because when they substituted, you can tell it was pled as Dr. Tolley individually, and now it's pled as Thomas C. Tolley, MD, PA, doing business as Thomas.
You're at your 3-minute mark. If you want to keep going, it's up to you. We want to save you 3 minutes for rebuttal.
Let me take one more minute. So the way it's pled now is an entity doing business in Pinellas County. So what we have is a completely different plaintiff. We don't have, as what appellee is saying, that just change the description. You can't change the description from a private person to an entity and say it's the same plaintiff. And the case that they cite is not even, none of the cases they cite deal with substitution of parties and standing. All the cases that they cite are all relation back cases, and those cases are all based because the statute of limitations would be blown. The last thing I would like to point out is that waiver is waiver. So a contract under law has to be safeguarded, and its contractual rights have to be protected, and one cannot act inconsistently with those rights. Not appearing in the 2019 action is a clear waiver under the law pled, and I will reserve whatever I have here for.
I'll save you 2 minutes. You're a little bit under, but let's say 2 minutes.
Thank
All
you.
right, Mr. Salter, you're up.
I think you're on mute, sir.
Yeah, you're on mute. Take your mute off. You're on mute.
Guys.
Now you go. Thank you.
Thank you, Your Honor. May it please the court. My name is Brad Salter. I represent the plaintiff in this action. I represent Dr. Thomas Tolley's medical practice. He operates as Thomas Tolley, MD.
Why don't we start with his first argument, which is waiver and standing?
Okay, his first argument of waiver and standing. Well, there is no waiver because under the law, the controlling case is Rafael. That's the case that says that when you look at the prayer for relief in determining the extent of what the judge can do, what the trial judge can do when there is a default. Here, the prayers for relief ask the court to decide the outcome. It was the same prayer for relief in the Rafael case as it was in this case. And when that's the situation, then a judgment can't be entered for greater relief than what is asked for.
Switch over to standing then.
Sure. As far as standing goes, the standing, My
said the party,
client
you named the wrong
was
party.
improperly pled. I readily admitted that from the beginning. But the law also states that when there is no doubt as to who the intended party is, that the court is with not only within its discretion, but always should go ahead and allow amendment to reflect both parties' intents. And here we have the defendant from day one in response to the complaint stating that the exact same party in the 2019 action, being my client, is the same entity as the plaintiff in this case, which we agreed with. We never took any position to the contrary. Their motion to dismiss had to do with the 2019 action. It didn't have it. They didn't say that it was a different party. And we simply said, as is evidenced in the order and is evidenced in our pleadings, that the motion to dismiss should be denied because they're asking the court to look outside the four corners of the complaint. So as it relates to naming Dr. Tolley, that was actually an issue that was noticed by me. So we went ahead and notified. And when the court was, when this issue was brought before the court on whether or not to allow us to correct our, Scrivener's error, the court had heard for almost a year us litigating, and everyone was always on the same page. I have provided the court with numerous documents where the defendant is consistently stating we are the same party as the party in the 2019 action.
The bottom line is you got a court order allowing the correction.
Yes, we did. And then not only that, in their answer, they admitted, Boliger admitted that he signed the LOP with the plaintiff as named. So that's why there was nothing bringing the error to my attention. I agree that we committed an error, but there was absolutely nothing filed by the defense in this case.
Saying it's basically harm.
It's not only harmless. Everyone was on the same page. As a matter of fact, if we look at Mr. Boliger, the deposition I took of Mr. Boliger, page 9 and through 10, I asked him of his first deposition, January 31st, I said, look, we have competing motions for summary judgment coming up. And keep in mind, the court ordered competing motions for summary judgment because the issue in the case is, did the 2019 action, did that invalidate the LOP? If so, my client loses. But if it didn't, then my client wins, right? So that's why the judge, we hadn't even filed our motion for summary judgment yet, only the defense had. But that's why the judge in the case management conference order that was entered on November 30th said we are going to have competing motions for summary judgment since it's both parties agree it's a win or lose proposition based on the 2019 action. And when I ended up taking his deposition prior to the motion for summary judgment, I asked him, Mr. Boliger, will you agree? It's your position that if the 2019 action invalidates the LOP, that you win. But if it doesn't, then my client is entitled to some recovery. And he said, and I'll just go to the bottom of page 10. He says, now, whether or not Ms. Frenzio separately for those damages for the medical bills outside the letter of protection, I haven't researched it far enough, but you're probably correct on that premise. Both sides from the very inception were treating this case all along the same way, that the plaintiff as filed in the present action is the same plaintiff that was in the 2019 action. There's zero prejudice. And so everyone was on the same page. And so the court correctly granted the motion to amend.
So my next question is there a specific reason why a letter of protection is used in these cases? And if so,
sure, absolutely,
say?
Judge. So a letter of protection was used in this case because Ms. Frenzy had no insurance. She had no way to pay for medical services. And there are few doctors already in this area because of the problems that are entailed with depositions, subpoenas.
So your client felt he could rely on the LOP for payment, And if he couldn't, then the attorney would be responsible to pay him. Is that correct?
100%. And not only that, I'll point out there, because there was talk about whether or not parole evidence was going to be required. This is a contract. This LOP contract is, as this court already noted in the prior written opinion in this case, the language is, quote, clear and unequivocal. It says, I, Attorney Boliger, agree to, withhold funds and not give any money to my client.
Well, the reason why I asked you all that, I'm not saying your doctor couldn't do math, but he didn't have to do math. He had a letter signed by a lawyer saying, I will pay you personally if necessary. And that's how he took it to mean. And as a lawyer, which is you, looked at it and said, yes, that's the correct interpretation, and you're off to the races.
It was a guarantee of payment. And really what it was a guarantee not to give his client any money until the balance was satisfied first.
Right.
And
that wasn't done. And that
I'm sorry.
wasn't done. That was not done. There was no interpleader action. The attorney dictated the beginning and the ending of the fund distribution.
That's exactly correct, Judge.
Gotcha. Okay, thank you.
So we have, there were a number of issues raised by Mr. Boliger on appeal, but the trial court was absolutely within her discretion, and the law is clear that she should have allowed the amendment to reflect what both parties contended to be the plaintiff is properly named. There was no waiver by virtue of the clerk's default. There was no collateral estoppel because there was no judicial outcome. There weren't the same issues, and Mr. Boliger wasn't a party to that action. So no aspect of collateral estoppel. And the damages in this case are liquidated because this wasn't Mr. Boliger didn't agree to protect a reasonable fee. What he agreed to do was to not pay any money to his client until the balance was satisfied. And according to the case law, it's clear that when it can be determined by the pleadings or mathematical or arithmetical calculation, that those are not liquidated damages. And so that's what we have here. So the court was correct in that regard. As it relates to Mr. Boliger, again, the LOP was clear and unequivocal. It stated specifically, the contract is only a paragraph. And at no point does it reference his firm. Now, Mr. Boliger has agreed, from day one.
He said it was on the firm letterhead.
That's not correct. At all. It's Thomas Tolley, MD, is the name on the top of the LOP, Judge.
That's just erroneous. Okay, I got you. Thank you.
So the paragraph signed by Mr. Boliger says, I, attorney at law, Mr. Boliger, agree to withhold monies from settlement or court award in my client's case in an amount sufficient to cover unpaid balances for services rendered by your facility to my client and to pay off those balances prior to disbursement of any proceeds to him or her personally. I've been advised by my client to protect for the services rendered relative to the above referenced accident from any proceeds to the case as stated herein. And that was signed Aldo Boliger. And so there's...
Well, the question is, if he gave out 13 of those LOPs, 12 or 13 LOPs, and it's not enough money to pay 12 or 13, did your client know at the time he was getting into a losing proposition, or nobody knew there was 13 positions in the case?
Well, there's a couple things. Number one, my client is not told about other providers and who they are. But number two, this LOP is executed at the inception of treatment. So there was no reason for my client to believe.
That's typical. Most cases go that way, correct?
Yes, sir.
Everybody knows that. Okay. I got
Yes, sir. So there was no way for my client to believe that at the time he initiated treatment for this individual, Ms. Frenzy, that the case would ultimately be settled for an amount less than the outstanding medical bills. But the one thing that is for sure is that it was my client's treatment and his opinions of causation that gave rise to the value of the case that was there. Mr. Boliger used.
That's kind of irrelevant, but you're saying your client was very helpful regardless, and he should have been appreciated more than he was, but that's not really germane to the legal issue, right?
It's not. It's not. It really goes to why I got involved in this case. I
got you. Keep going. You got a few minutes left. If you want to use them up, it's up to you.
Well, I think I've addressed the issues. If the court has any questions of me, I'm happy to answer them. I feel like we've addressed the issues in the briefs pretty well. I would like to take a moment, if I could, because I filed some case law earlier this week, and that was an error on my part. It was harmless. I'm not, although I may be board certified in appellate law by the end of this case, I'm not an appellate specialist.
You filed a motion to strike, which was granted, is that correct?
I did not file the motion to strike. Mr. Boliger did, but once I read his motion, I saw that I was in the wrong. And so I already drafted an apology.
Well, you can file that later. It's not a big deal. But thank you.
To your staff and to Mr. Boliger, because it was nothing sinister involved. It was just ignorance on my part as far as that goes. So, but the judge was absolutely within her discretion. She followed the law in granting the amendment. The judge followed the law in granting summary judgment in favor of my client, and the judgment below should be affirmed by this court. So that's all I have. Thank you very much.
All right, man. Mr. Boliger, you've got 2 minutes left.
Okay. Well, first off, the motion to amend to substitute the party stated no new parties will be added. That's one of the things that you cannot do. You cannot add a new party plaintiff. So that was a misrepresentation in the motion. I filed a response to the motion attaching evidence of the corporation and things like that. I requested an evidentiary hearing. No hearing was held at all. Instead, the trial court just entered an order basically allowing them to substitute parties. So you cannot, the plaintiff at all, they're making all these allegations that I somehow admitted that there was standing. I never did that. You have to imply that. Moreover, it is purely a plaintiff's obligation to maintain and prove standing at all turns of the case. They don't have standing. They have Dr. Tolle individually in the beginning here for almost the first year litigating this case. And yes, it's quite prejudicial because they said there's a difference. There was no identity of the parties because Dr. Tolle is different than the Tolle Corporation.
But my question is, the argument you're making today, you could have made to the trial court a year before you did it. Is that true or false?
I did make these arguments.
But what I'm saying is it took you a year of litigating to come up with that prejudicial assertion?
Well, not the prejudicial issue, but I pointed out to opposing counsel numerous times you don't have standing. It's not my responsibility to maintain the standing. That's plaintiff's own.
No, I'm not. All right, I get it. You got 30 seconds to go. Keep going if you got something new you want to say.
Yeah, so that's it. The other thing, the LOP does not create personal liability. The only thing that the LOP states is that I will withhold funds. It doesn't say I'm going to pay the funds or my law firm is going to pay the funds. So now I'm in the unfortunate position that I'm supposed to pay this Dr. Tolle $60,000 of inflated medical charges when he's in a better position now than he was if he had shown up. So he never shows up and he gets full payment while all the other parties had to take 50% reductions. So that's just patently unfair.
You just used your time up. All right, I gave you a little bit extra, but you're out of time. Gentlemen, thank you for your argument. We're going to be in recess now. Have a nice day.
Thank you.